Afternoon, good morning. My name's John Siegel. I'm here with Joyce Ackerbaum Cox. We're the co-leaders of the Baker and Hostetler National Non-Compete and Trade Secret Practice Group. Here for the February session of our webinar on non-competes and trade secrets. Today's titled Future Shock: How to Protect Trade Secrets When Non-Competes Become Truly Disfavored. So for those of you who have watched this series, and for those of you just perhaps joining us today, let me just quickly give you a very oversimplified summary of what we've been talking about in the last 5 sessions in terms of the trends in this area. What we've been describing and analyzing is a rapid and ongoing change in the world of non-compete and trade secrets law. The basic conclusion and advice is, because of such rapid change, we really can't rely on our old knowledge and our old strategies that we and our companies and our clients have done for years. There needs to be a revisiting and a re-strategizing in a lot of areas. 5 years in, the Federal Defend Trade Secrets Act hasn't yet really changed the law materially, although it has very clearly and substantially moved cases involving trade secrets claims to the federal courts. But paradoxically, the DTSA has not met, at least yet, its stated objective of unifying the law nationally. And at the same time, on a parallel track, state laws are becoming ever more divergent for reasons we've discussed and will discuss today. There is, it's fair to say, a national movement to restrict and limit the use of non-compete agreements. State statutory prohibitions and regulations on the use of non-competes for lower salaried employees are becoming prevalent. Attacks and limitations, both in the courts and statutorily, on the use of non-competes for purposes of what some call restraints of trade, protecting client and employee relationships, are on the defensive. There's a distinct possibility of federal rulemaking by the Federal Trade Commission, as we've discussed. And in addition, the use of non-competes without notice or without additional consideration is also subject to revisiting and reevaluation in a lot of jurisdictions. At the same time, as we discussed in our 4th session, extraterritoriality and the use of the DTSA to seek to protect trade secrets globally beyond the borders of the United States is clearly the next wave that's happening in the federal courts, and we all need to follow that closely. And at the same time, as we discussed last month, criminal enforcement against no-poach agreements is here, it's real, and it's something that every company and every client needs to be concerned about. So with that ridiculously summary description of what we talked about for the last 5 months, Joyce, where does that leave us all?
Good question. I think that it leaves us with a mixed bag. I think it leaves us with businesses having to be very careful with the non-competes they choose to use, with businesses being very thoughtful about alternative methods that they can employ to protect their assets and their secrets, and with what I would say a healthy dose of we don't know, because the law is just continuously changing. It is going to be unfolding at both the federal and the state level, as you mentioned, certainly with this administration and with a lot of pending legislation in other states, and certainly legislation that's already passed. So while the topic of this is how to protect trade secrets when non-competes become truly disfavored. Before we get more specific, I want to talk about just kind of 5 key takeaways or recommendations when we're talking about non-competes themselves. Recent kind of studies show that 18% of the current U.S. workforce is subject to a non-compete, and about 38% of workers have at some point been subject to a non-compete. So it's very prevalent out there, and all of our, many of our clients, many of you on the call today have used them in the past or currently are using them. So I think that I want to talk about a couple key takeaways and things that you can think about and consider when leaving here today. And this is from the perspective of if you are the employer drafting the non-compete. Certainly, the reverse holds true as we defend a lot of these cases as well. This is one area where you do both sides, employer, employee, departing, company, hiring company, et cetera. But this specific advice is really from the drafter's perspective. So I want to make that clear. I think first and foremost is you've got to give very significant thought to who in your workforce needs to be subject to a non-compete and who doesn't. So long are the days that you give everybody a non-compete as part of onboarding, from the CEO down to the janitor or the receptionist. You have to be very mindful of who can harm you and how they can harm you. Is it going to be by confidential information? If they leave, they're going to take that with them. Is it going to be by trying to take your customers? Is it going to be because they have some sort of a recipe or a formula or something like that? Is it going to be because you've spent an extraordinary amount of time putting them through a training program that is particular to your company? So you've got to be very mindful of what it is you're trying to protect and how. And that's an important kind of starting point when you're thinking about crafting a non-compete. Also, I think it's really important, and it was mentioned earlier in one of the webinars by our antitrust partner, Ann O'Brien, that's particularly relevant in the antitrust context. If you have a company, if your company has a culture that is one that never has and never will enforce a non-compete, or you work in an industry where you have the type of workforce where it just, doesn't work, and there's a lot of industries like that. If you're not ever going to enforce the non-compete, then, it really shouldn't be in the confidentiality or other employment agreement, or shouldn't be a freestanding agreement. It shouldn't have it at all. I think that that's really important, because that's actually used against companies in a lot of the litigation right now that we're seeing in the antitrust field, where they have it and they say, oh, we never even enforce it. That's actually used against them. The second kind of takeaway is that think about other ways that you can seek to protect your company's legitimate business interests other than non-compete. So can you rely on a non-solicitation agreement? And of course, this is in states where, non-solicitations are viewed differently than non-competes. And I believe John talked a little bit about that in his last webinar. But, non-solicitations may very well protect what you're seeking to protect, them going after your customers or, your other employees and that sort of thing. Think about garden leave payments. Is it, do you want to keep someone on the payroll and therefore keep them having a duty of loyalty to your company, even though they're not, continuing to actively, work for you? That's an option. They do that a lot in the UK. They have for a long time. I think that's something that we're going to maybe start to see more here. I think another option might be clawback of severance payments. A lot of, certainly for the executives, we pay out, companies pay out severance payments. They do it sometimes in tranches and things like that. If there's a violation of an agreement with respect to providing confidential information or trade secrets or working for a competitor, then you can look at clawbacks of those, as well as repayment of training fees. Like I said, if there's a particularized program that you put an employee through or something similar, maybe that's, kind of a hook to keep people from, leaving and going to another company. But of course, there's a lot of state law considerations for each one of those sorts of things, but they're just different options. And so I think that that's what we have to do, is think about different options here other than the traditional non-competes. So the third kind of takeaway that I want to mention is you've got to go in now and review existing employment agreements and agreements that are freestanding kind of non-compete or non-compete or non-solicitation confidentiality agreements. There is no one size fits all. I think if there's, one major theme that John and I have tried to express throughout this entire, 6-month webinar series is that there is no one size fits all. And we get a lot of frustrated national, multinational, international companies that say, I can't have 50 agreements for each different state. And that's perfectly understandable. But there's a lot of different approaches you can take. So you can do a state-by-state approach. You can do a regional approach. You can do a national approach. But if you decide that you want to have one on a national basis, you need to understand there are places that it's never going to be enforced, or that you're not even allowed to put them in writing in the first place. So there's a couple states that you're going to want to have a pullback for employees in those states. And you have to understand that the impact on the business is that if this is a violation that occurs in one of these states, it's not going to get passed. So it's something that you weigh from a business standpoint if you want to have something, on a national level. But there are other different ways to, approach it, somewhere between one agreement and 50 plus different agreements. We can certainly help you with that, but that's tough. When you're actually looking at the non-compete, one of the things that John and I see all the time is people define their business or their competing business as very, very broad. If you are a parent company or multinational company, you've got many, many different products and lines of business, which very unlikely have anything to do with, or most of which have nothing to do with perhaps the employee at issue in a non-compete. So you need to specify what it is that this employee is touching. What line of business is he involved with? What particular subsidiary, what particular company? You don't want your company to be so broad that you're trying to basically prohibit the individual from, working altogether. So that competing business needs to be as narrowly tailored as possible. And sometimes that can just be the name of the, by addressing the name of the employer that is a party to the agreement. Something to think about. Also, obviously defining the geographic scope as narrow as possible. That's really hard these days, given that everything is like we're doing now, Zoom, and you can reach people, nationally, internationally, so easy. But there are still places where individuals have, customers in a particular region within a state or multiple states or whatnot. And so you want to tailor that as specific as possible to the business that the employee is covering for the employer. Along these same lines, the choice of law is critical, and I cannot stress this enough. We've mentioned many times about how many new statutes have gone into play. I think, John just again mentioned about lower income employees, being, statutes being passed to not pertain to lower level employees. I think there's probably 10 new statutes, states that have done these. I recently read that it's also not just going to be the blue states. Some of the red states are starting to participate too. So Iowa and West Virginia have pending legislation in this area. And I think one thing that's important when people think of lower level employees, we're not just talking about fast food employees or hourly employees. I mean, in some states, the threshold level of a lower level employee could be $100,000. So you've got to be aware of what your statute says in your particular state and how lower level, is defined. Many times it might be, X times the minimum wage or something like that, but it's got a different definition based upon the statute, and you've got to be aware of what that is and pay attention to all the new legislation. And of course, we're always tracking and paying attention to what is going on at the federal level if something's going to come out in terms of some sort of national federal legislation. So the other thing when you're looking at a choice of law is being mindful of which states blue pencil or modify and which ones don't. This is particularly important. For example, Florida will modify and will blue pencil. So if you've got an agreement that's overbroad, they will, strike it, rewrite parts of it so that it make it reasonable. Other states won't. They'll just consider the whole thing unenforceable. Or some states will just draw a line through the offending language, and if what's left doesn't make any sense, then you as the business trying to enforce it are going to be in a bit of a predicament. So think about how that blue pencil modification standard is going to come up in the states that you're looking at. And I think it's also important to be mindful that a lot of jurisdictions are not going to accept your choice of law provision regardless of what you put in there if it offends their public policy, or there are not acceptable ties to the jurisdiction. We see often people say, well, I want to put, X state law because I think it's really favorable in my non-compete. I'm like, okay, well, what ties does your company have there? What ties does the employee have there? And if the answer is none and none, or even none on one side or the other, that could be problematic. So, the choice of law, I can't really overstate how important, the choice of law analysis is when crafting. When you're reviewing your employment agreements, I think it's become very clear that you've got to remove the no hire language. I think that is just on a going forward basis, that is very dangerous to subject any employee to a you shall not hire our employees away from our company. We've seen the danger in this type of no poach language. In fact, there are states that have on the books no poach statutes that have never been enforced or, don't have any case law when you look them up. For example, Florida is one of them. But I think that, if this sort of a trend continues, people might start to invoke those, of course, not to mention what's going on, with DOJ and all the things that Ann O'Brien spoke about from an antitrust standpoint. So that's just kind of from the employee-employer angle. There's, of course, the whole area of third-party agreements that your company might have with other companies, with staffing firms, and things like that. You also need to review those agreements with a particular eye towards antitrust issues that Ann O'Brien spoke about, certainly eliminating no hire language in those, beefing up areas where you're identifying what the interests are so that they're apparent on their face. Those things are very important because, we talk to a lot of clients that continue to just renew the same agreement year after year after year. They've been in place for 10 or 15 years and nobody's actually read the bulk of the agreement except to change kind of the dates of operation and maybe the cost. And that's a problem. Got to go back and look at those, and now's a good time as any. And I think the last kind of takeaway, the fifth takeaway I would say, is really training your employees, particularly the HR staff, your C-suite employees, and those that are negotiating third-party contracts on the antitrust issues that we talked about. There is that guidance out there for HR professionals. If you haven't read that or haven't made sure that your HR folks have read that, we would highly advise that be provided to all of your HR individuals. But annual training on these sorts of things is really important because it's a simple email or sometimes a simple comment that companies share one to another that might get you in hot water with the Department of Justice. And given their uptick in civil, and criminal filings and enforcement under this administration, it's something to be particularly aware of. Of course, as John mentioned, as I've said, even doing all of this, we have no certainty, no guarantee of enforcement. A lot of times, as I tell my clients, it really the luck of the draw of the judge, because some judges will always hate these and some will like them, and you never know. But I think we're getting more to the point where it's going to be more and more problematic rather than kind of the flip of a coin. So having said that, John, I'm going to turn it back to you and talk about what impact will all of these kind of restrictions and scaling back on non-competes have on kind of trade secrets and the litigation of trade secrets moving forward.
Well, Thanks, Joyce. I mean, you know, we don't have a crystal ball and we're not here to make, to see the future. We're just trying to see the issues as they might arise. But I think that clearly based on the skepticism and legislative and judicial disfavoring of some purposes and rationales for enforcing restrictive covenants, we should all assume the relative importance of the trade secrets rationale to enforce restrictive covenants will greatly increase as skepticism on restraints on soliciting or converting customer relationships or employee solicitations grows and enforcement is scaled back. So what do you do? This certainly increases the importance of not just relying on a non-compete or a restrictive covenant, but having adequate and appropriate trade secrets agreements in place with employees, whether, you know, some bundling of confidentiality agreements, non-disclosure agreements, intellectual property agreements, inventions agreements, work for hire agreements, all the things that protect a company's trade secrets and confidential proprietary information, so that you're not just relying on a non-compete or an employment-based restrictive covenant, as those perhaps become ever more disfavored. The trade secrets agreements, like what Joyce said about employment-based restrictive covenants, really need to be specifically tailored to the business context and situation, not just in the company, but to the extent possible, the employee's role, to identify the technologies involved, identify products involved, processes, and employee roles. You know, most of these agreements that most of us see and have written over the years have a broad general definition of trade secret, usually derived from the restatement, perhaps now from the Uniform Trade Secrets Act or the DTSA, and that broad general restatement of the law is going to be less effective than trade secrets types agreements that really are tailored to the specifics of the situation when you're trying to enforce them. Trade secrets audits are highly advisable. They're a great idea, and frankly, most companies never do them. They do them after the fact when the problem arises, right? And it's especially true to proactively review and analyze and make sure you have buttoned down your measures to maintain secrecy so that you can demonstrate actual real implementation to meet that secrecy requirement in a trade secrets case, and not to be trying to cobble it together later, but to be able to show password protections, protection of vital information on a need-to-know basis, not simply stamping everything confidential and thinking that that's going to do it, but really in an analytical way, going through, reviewing the procedures in place and improving them. It's also very true with regard to specifying trade secrets. You know, I've seen so many cases, I've been involved in so many cases on both sides where it's, okay, there's a misappropriation of trade secrets, there's a claim, now let's figure it out. How do we specify it? How do we detail it? How do we explain it to a court? And the days of being able to do that over the course of a litigation in discovery are numbered. Under statutes and procedures in a lot of states, specification of trade secrets is required early on. And if you're scrambling to do it in a litigation context, it's very different and very less effective than if proactively you're looking at what you're going to need to protect. You're able to define it with some specificity. You're able to identify who has access to materials or processes or information and how those things are protected. Having said we're not here to see the future and don't have a crystal ball, let me make a few predictions that next year or 5 years from now you can call me on. But I think that based on what we've been discussing, these are assumptions that you should use in your business planning and your litigation planning. First, the DTSA will continue the trend of cases migrating to federal courts. The filings in federal courts are way up, and there's every reason to think that will continue. I believe at the same time, though, that federal judges will start to push back on this. And the assumption that because there's the DTSA and because it's a federal court, that it's always the right place to bring a claim is something that you should look at skeptically and think about in any litigated situation. Federal judges will push back. I've seen it happen in cases where judges don't just sit back and let the cases develop, but they apply the stringent standards on a motion to dismiss in a federal court. And I think that we should expect some screening process by federal judges, especially in high volume jurisdictions where they're going to see a lot of these cases. They know that 70, 80% of the cases that are being filed in federal courts are cases that were garden variety, trade secret, or non-compete cases filed in the state courts prior to the DTSA. And they will naturally look for ways to limit access to their docket. So I think you've got to push back against the idea that because there's a DTSA and subject matter jurisdiction, you always bring these cases in federal courts. I think there'll be a blowback on that. US courts, US federal courts are and will increasingly attract extraterritorial claims in trade secrets cases. It's an available forum. We all need to watch how the case law develops on this, but if the case law continues to permit such filings, it's going to be a very attractive forum, and there'll be more and more cases. And something that is not really in the nature of prediction, but in the nature of something to think about, is that if these trends towards more stingy, if you will, enforcement of restrictive covenants continues, and perhaps a tighter screen on trade secrets cases that go all the way into discovery and towards trial, I really urge people to consider whether and when arbitration is a relatively more attractive place for plaintiffs bringing these claims. It depends on the industry. It depends on what arbitral forum. I certainly could say from experience in the financial services world that FINRA remains, a very available forum with not only injunctive relief, but perhaps a greater acceptance of damages claims in trade secrets and restrictive covenants cases than in a lot of courts. And so I would urge people who are thinking about where to bring claims and how to bring them prospectively and drafting agreements to think about arbitration and where does it make sense and where might there be industry or other arbitrable forums that are more attractive venues. Whatever happens, I've seen this for 25 plus years practicing in this field, as many others on the call no doubt have, but whatever happens, I have no doubt it will continue to be the case that nearly every company believes that nearly everything it has and everything it does is a trade secret, or at least proprietary confidential information that's protectable through agreements. And at the same time, that nearly every departing employee believes or claims they believe that nearly everything their company does is not a trade secret. And we all know the truth and the facts lie in between those two polarities. And that's why there's so much trade secrets litigation and will continue to be. And no matter how these statutory regimes evolve, and no matter how the case law evolves because of those competing tensions, we're going to continue to see a lot of activity in this area with for all of us to do and learn. And so we look forward to keeping in touch with you all and talking about it. And Joyce, let me kick it back to you to close out, and thank you all for listening.
Yeah, thanks, John. It would be nice if we had a crystal ball in this area for sure, but there is going to be a lot for us to keep our eye on in the coming years. This brings us to the conclusion of our webinar today and of our 6-month, 6-part webinar series that we have conducted for you over the last several months. We thank everyone for joining us. The attendance has been wonderful. The questions that you've submitted have been great. We really appreciate it. Please let us know if there's anything that we can do to help you. We've got obviously a national team of people sitting in a variety of states, and we, cover this from the drafting all the way through the litigation stage, and can help you in any way that we can. We'd also be happy to hear from you if there are particular subjects that you'd like to hear about from us with respect to future webinars, whether it's a one-off or if we, opt to do kind of another series. Maybe it will depend on what the FTC and what the Biden administration do. Certainly, if that comes out, you'll be hearing from us. Just in closing, the 2 housekeeping issues that I always say: fill out the form. There's CLE credit available in most states, and all of these webinars, the 6-part series, is available on a podcast. So not that I ever want to go back and listen to my own voice, but they are out there available if you thought that something was particularly interesting or you missed a part that you really wanted to hear. I know some people reached out, they missed the multi-state, update, or what Ann O'Brien had to say on antitrust, or any of the DTSA or extraterritorial application. The podcasts are there and they're available for you if you want them. So we, again, appreciate your attendance, and please reach out and let us know if you have any feedback or we can help you in any way. Thank you so much. Have a great day. Bye-bye.